Lorainne, thank you very much.
Morning. Can you hear me?
Yes, I can hear you. Can you hear me?
I can, clearly.
Thank you. Thank you, Lorainne. Thanks for coming on. Apologies to our listeners and participants for a minute or two later start. But nevertheless, we get going. Very good morning to everyone. On behalf of Minara Chamber of Commerce, I welcome you to the I welcome you in the universal greetings of peace. This morning we have Lorainne Moonsamy, who will walk us through a very topical subject, which has become law, I think, in South Africa. And the topic for today is, why should we ensure your entity is POPI compliant? POPI is an acronym for Protection of Personal Information Act. And that act actually comes into play by the end of this month, the 30th of June, 2021. Before I ask Lorainne to take the floor, let me take this opportunity of introducing her. Her CV is quite long, I assure you, but I will walk you through some of the highlights of her career. Lorainne is graduated with the Bachelor of Arts degree at the University of KwaZulu-Natal, majoring in psychology and criminology. She later went on to complete her honors degree in industrial psychology through University of South Africa. Having been already placed in a senior HR management position, she decided to further studies by registering for a master's degree in human resources. Lorainne worked in various sectors. However, the bulk of her years has been spent in manufacturing and in highly volatile unionized environments. Oh, that's a hot seat. Lorainne is passionate about human resources, and the main objective is to empower line management in small to medium-sized organizations and to manage and maintain a healthy working relationship between management and the employees. So with that short introduction, but very powerful introduction, Lorainne, if you can walk us through and enlighten us on the POPI Act. I'm sure most of us are looking forward to knowing a little more about that. Thank you very much, and over to you, Lorainne.
Okay. All right. Good morning to everybody that's logged in, and thank you, Mr. Razak, for that nice introduction. I think, like you said, POPI, very topical. I'm just going to run through because I'm just obviously very concerned about time and mindful of time. There's a whole lot, like I said to Amina, about POPI. So I'm not sure if 30 minutes is going to do justice, but I'm going to try my best to give you a nice overview, very comprehensive overview. So like Mr. Razak has said, obviously POPI is something that that's come about. The only correction is that it's come about in July 2020. There's been a grace period given to employers for the last 12 months. And that grace period comes to an end at the end of June this year. So basically what the law requires is that every company needs to be compliant from the 1st of July, 2021. Okay, so again, POPI, just to start off with, POPI stands for the Protection of Personal Information Act. And basically it affects the manner in which companies collect, store, process, and disseminate personal information. All right. So if you are an entity that's operating in South Africa, there's really no exemptions to the POPI Act in terms of entities. So if you're a registered business in the country and you're operating as a legal entity, then you are required to have a POPI policy and a POPI manual that will basically guide you in how you accept, how you process, and how you eventually disregard the information or destroy the information that you have, personal information that you may have of what we call in the Act data subjects. So data subjects would be referring to employees, your clients, your customers, your contractors. You might have students working for you as interns. So any employee or any person that is involved in the business of whom you may have some of their personal information. Okay, so just very quickly, and apologies for not being able to do a slideshow, so you're going to have to do a lot of listening, unfortunately. A data subject would be the person to whom the personal information relates to. The Act refers to, so you're going to be coming across these terminologies and these acronyms and things. I thought I'll just get that out of the way. So data subject again is referring to the person whom the personal information relates to. Responsible person or responsible party would be the public or the private body that processes the personal information. So that would be the entity, the company, right? So if you are accepting and receiving personal information about an employee or a person or a client, you would be regarded as the responsible party. An operator is generally a third party. So if you have a company where you outsource work to and you then divulge confidential information about your employees to the operator, then that would be the operator. So for example, like a payroll company, where you'd outsource your payroll, you would then give out personal information of your employees for the sake of processing payroll. So what the Act says is that the responsible party has to have an SLA in place between the two parties to make sure that the operator is compliant with the Act, so that that information that you've entrusted in their hands is protected. Okay, an operator is not subject to POPI, by the way. Okay, it is the responsible party that is subject. But the responsible party has got to make sure that there is a signed agreement between the parties that the operator will protect the information. And then you have the regulator. Okay, the regulator, the information regulator, as we call him. We have to go onto the portal and register the information officer. So the regulator takes care of the Act and champions the Act, whereas the information officer, who is an internal resource at the company, generally the CEO or one of the directors, that will take the responsibility of being the information officer. And that person basically would have to be registered on the portal by the 30th of June. And that person becomes a responsible party. So if you understand employment equity, you have an employment equity senior manager. So basically that individual is responsible for that particular project at the company. So if there are any claims, any complaints, any issues arising from protection of employment, personal information, that will be the go-to person, and that person will take the ultimate responsibility if there's any breaches. Okay. So what is personal information? Okay, so this obviously my presentation is very, very basic, and it's giving you grassroots information for those of you that might be new to this, and I think a lot of people are new to it. So what is personal information that we're referring to? We're referring to race, gender, sex, pregnancy status, marital status, your nationality, your social origin, your color, sexual orientation, age, physical or mental health, your well-being, your disability status, your religion, your belief systems, your language. So that is referred to as personal information. So obviously, those of you that are employers, you would know that when you recruit an employee, you have an application form, an employment application. And on that, the employee basically gives you their personal information. All right. So you are required to protect that information. Okay. And there's various reasons for this act coming into effect. For the sake of protection of employees from fraudsters, possibly people being intimidated, if you've been called as a witness, and then if your personal information has been leaked out, your security becomes is at risk for your safety. So those are the reasons why the POPI Act was basically born. Okay. So basically, the Act allows companies to accept personal information. However, it needs to be processed in a very responsible manner. Okay. Just give me 1 second. Shah, will you take that outside? Okay. Sorry about that, guys. Okay, so a responsible party is required to process lawfully information, and there are 8 conditions. Okay, so I'm going to go through those 8 conditions because that's what the Act requires you to do, and but I'm just going to touch very briefly on those 8 conditions. So one is accountability. So the first condition is accountability. So accountability would basically involve the fact that you have a POPI manual, a POPI policy, you've appointed an information officer. So that shows that you are accountable. You're taking account for this POPI legislation, right? You put in place contracts with the different providers that are within your entity. And then you implement security measures, because that's what the Act also requires, that you have to show how you would safeguard the information that has been entrusted in your hands, right? The second condition of the Act is processing limitation. Processing limitation basically refers to having received consent for you to have this information, and only having what information is necessary for you to have. Sometimes as employers, we ask for information that might not necessarily be relevant for the person's job. I'm trying to think of an example that I can give you to illustrate that. If you employ somebody, does race, okay, probably race would be required because of employment equity reasons, but marital status, is it relevant for you to know whether the person is married or not, and for what purpose? So processing limitation refers to the necessity of you having that information. Okay, so basically what the Act is saying, employers need to only have information that is necessary for the smooth working between the employer and employee, and they must not have excessive information that is not required. Okay. Purpose specification, that's a third condition that the Act requires. So this is how you would go about processing that information. Okay, so these are the conditions that you have to abide by. So purpose specification is that the information must be collected for a specific purpose, not willy-nilly, not nice to have. It must be absolutely purpose specific. And when you no longer require that information, then you have to have a policy, or your policy has to include how would you now destroy that information. How would you, so that it doesn't create a risk of being leaked out and then getting into the wrong hands. Okay. Further processing limitation is the fourth condition of the Act. And further processing limitation basically says, if you collect information from an employee and then you use that information, all right, and then say, suppose you collect that information for a specific purpose, and thereafter you want to use that piece of information for another purpose. So it says that if you're going to use that information for another purpose, then you would need to get further consent from the employee. So if you get information from an employee, say suppose the employee has come on board, you've filled in the application form for the purposes of payroll, and say suppose you now need to divulge that information to a third party, say for example to the medical aid company. So your initial requirement might not have been for medical aid reasons, but the second requirement could be. So what the Act says is that you have to then require consent, additional consent from the employee, especially that you're going to be using the information for a different purpose. Okay. The fifth criteria, or the fifth condition that the Act requires, is information quality. All right. So what it says here is that the responsible person must take reasonable practical steps to ensure that the personal information is complete, it's accurate, and it's not misleading, and that the responsible party, which is the employer, must take account of the purpose for which the personal information has been processed. Okay, so the quality of the information you receive has got to be accurate. Okay. Openness, okay, openness and transparency. That would be the sixth condition. All right, and openness refers to the data subject, which is your employee, your client, your customer, your patient, whoever that person may be. So data subject must be aware of what information is being collected, the name and address of the responsible party. All right, the person needs to know where the information is being stored. The purpose of why that information has been stored, and whether that information that has been collected has been voluntary, or has it been a mandatory piece of information that the employer or the responsible party require or needed to have it. All right, so that's openness. And then security safeguards is another condition, okay? And that's probably one of the very most important ones. is that there has to be measures in place by the employer, by the company, to state how they would protect this information. And there's various ways. You can have a filing system that's under lock and key. You need to state in the policy who's got access to that cupboard. What happens if that information gets leaked out? What's the recourse against the person that has leaked that information? All of these things goes into your policy. You might have soft information in terms of electronic information. How are you going to protect that? Employees take laptops home. What would happen in the case if an employee's laptop was accessed by a family member and personal information about an employee was taken out of that? How do you protect that? Do you put passwords in? Do you encrypt your passwords? So we look at technology. We look at your IT policies. We look at your emails. We look at from a storage perspective, electronic storage, as well as your hard copy storage. So in the policy, an employer would have to put in place. What are you putting in place? What are the mechanisms that you've put in place to basically protect that personal information of your employees? All right. Also, staff training. So if you've entrusted personal information to employees in your company, for example, the HR department has got a lot of confidential information sitting in there about personal information. What are you going to do? How are you going to train those employees in HR to understand the implications of that information getting leaked out? Because it could mean life and death of employees. That's how serious it can get. Obviously, it's quite drastic, but those are some of the things that can take place. And then the last condition is called data subject participation, where the employee has got to give consent, again, for the information that's been volunteered, and is aware of why that information is required by the company. All right, so those are the 8 conditions that the company, every legal entity in South Africa has got to comply with if they have on-site personal information of employees, and of course, other data subjects. The other aspect of the Act, sorry, I'm just running through it because I'm just concerned about time. There's quite a lot of information, so I've given you a very brief overview. Direct marketing, okay? I think a lot of us are quite annoyed sometimes by the amount of telephone calls that we get from call centers, etc. But direct marketing, okay, it's not allowed unless consent has been given by the data subject, or the data subject is a customer of the responsible party. And if the responsible party has obtained the contact details of the data subject in the context of a sale of a product. So if you go to a store, you purchase a product, that becomes, you've given your information, and then, normally you get asked, can we contact you? If you've given consent, then obviously they're allowed to contact you regarding a further sale or a further promotion that they might be having in store, etc. So they've got your consent to use your details to contact you. All right. Other than that, it would not be legal. If you are sending information of your employees trans-border, so basically to another country, you would need consent from your employees if you're going to be transferring information. That's referred to as trans-border information flow. Okay, that's not allowed unless consent has been given. And then the not so nice part of the Act talks about the complaints and the fines and the implications if you do not comply. Sorry, I've got a WhatsApp from Amina. I just want to see whether she's... Okay, cool. Thanks, Amina, for that feedback. Excellent. Okay, so the first step in the process would be obviously to register your information officer with the regulator by the 30th of June. And the fines, I have to tell you, they range from, this is for non-compliance, they range from 1 million up to 10 million. And they also go from 1 year imprisonment up to a 10-year imprisonment. Okay, and that would be the information officer that would be obviously implicated. So you can, if you are fined or you are found to be non-compliant, you can appeal within 30 days of the information regulator being in contact with you. You can either choose to pay the fine, you can choose to make payment arrangements to make the payment, or you can then basically ask to be tried in court if you're going to, if you feel that you're not guilty of whatever the complaint has been, or the non-compliance. And obviously that fine gets paid over to the National Revenue Fund. I've kind of gone through, I left more time for questions, Amina and Mr. Razak, because I've gone through quite a lot of content, but I've kind of raced through it because I was wary of time. So basically, I've taken you through the main requirements of the POPI Act, and what is required. So I'm pretty much done with the presentation, unless you want to open it up for questions.
Thank you, Lorainne. I think that was very insightful. It gave us an in-depth idea of what the POPI Act actually requires us to do. I think there were a few questions which popped up here and there, but I think what had happened is, as you went through the presentation, one or two of those questions had been answered by you already. So I'm not going to, in the interest of time, not going to actually pose those questions to you again. One of them was actually about the fine and the breach of the Act. And of course, you did allude to that by saying that there's a fine of 1 million rand or 10 million rand, that kind of thing. So that was answered. The other question that came up was about slides. If they're available, would you be able to pop it over to Amina and then for distribution to the rest? Are there any slides, or can we?
I can quite easily put something down together. I haven't done it. I've just prepared, but I'm happy to put a slideshow together in terms of information.
Okay, we'd appreciate that. Thank you. Just some of your bullet points on some of those areas that you had covered would be fine.
Okay.
All right. I take it that the personal information that the employee gives to the employer in terms of health would cover HIV and COVID-19 and those kind of things, mandatory, am I right?
Correct. It would depend on, like, obviously with COVID, that's quite important because of contagious and all of that. But yeah, I think, again, that is considered to be personal information. And unless you can justify why you need it and why it's required for the person to perform the position of the job, then yeah, you'd have to get consent. If it's an inherent requirement that the person has to be fit, and it's basically like how you do medicals when you go for an employment position. If you are required to be medically fit for the job and they can prove that, then yes, you'd be required to undergo medicals and disclose that to the employer. Other than that, if you can't justify as an employer why you need that information, then yeah, the employee is not obliged to divulge that information to you.
Okay, that's fine.
But I think the main thing is here is if that information is divulged, that's the one part of it. The second part is how you as an employer is going to protect that information. Because remember, this is the protection of personal information. So the employee can well give you that information, but the thing that we're discussing here is how are you as the employer going to protect that, and from somebody else finding out about that information, that somebody that's not authorized to know about that information.
Yes, that's fine.
Because it becomes your responsibility as an employer then to protect that information.
Sure, of course. All right. What I'd like to do for the next 5 minutes is just ask the participants to probably pose their particular questions. I see there's a few that's coming up, and I'm trying to actually talk to you and write down those questions quickly. But I think if the participant can just pose those questions quickly, because they know exactly what they're looking for. So we'll open it to the floor very quickly.
Okay.
Hi, Chantal. You can go ahead with the question.
Hi, thank you. Just with regards to the information officer, would this be solely a new position within one's company, seeing that the role is such an important role in one's company, that seeing that this does take quite some time, and yeah, maybe you can give me some guidance on that.
Thanks for that question, Chantal. I don't see it as an independent position. I see it in and amongst a current role, obviously a very senior role, generally the Act refers to the CEO or a director of the company that will obviously be overseeing the whole protection of information in the company. So I don't, unless it's a huge entity, you know, it's got thousands of employees where this becomes a full-time position, I really wouldn't recommend that, that, you know, you have a full-time person unless in that case. But other than that, it's in joint sort of a tandem with the current list of responsibilities. So like I said, the Act refers to CEOs and directors of the business. So somebody senior enough that will be able to access the information, that has a, you know, bit of clout in terms of security measures, IT, and that kind of thing.
Hi, Tracy,
Thank
you
you.
can go ahead.
Any other further questions? Is there a template for a POPI manual for NPOs?
Well, basically, there is an analysis, a gap analysis that you have to do. So basically, it's a status quo gap analysis. So you'd have to look at your current mechanisms that you have in place that protect your information, and then it's actually a very good exercise. Besides this being a tick box from a compliance, it also forces you to look at your business to see where there might be loopholes and where you've been kind of lax in terms of information. So it then forces you to put procedures in place that will protect that information. So what we do is we do a gap analysis, and then that gap analysis will pull out any loopholes. And from there, we then draft a policy manual that covers you.
Okay, and how would one go about registering the for POPI?
You'd have to go onto the information regulator portal.
Okay, all right.
And you basically have to put in the details of the information officer that you've allocated for that function.
Okay. NPOs, must they register as well?
Correct. As long as they've got personal information of their employee, then yes, the answer is yes. Yeah.
Okay. All right. Good. I don't see any further inputs or questions on that. Then I think we should start wrapping up. Lorainne, thank you very much. First of all, to our listeners and supporters of Minara, thank you for affording your morning hour for this very important act that's coming into play in about 10 days' time. And then, Lorainne, thank you for sharing with us your expert knowledge and giving off your time, your valuable time, and amidst your very busy schedule. We thank you most sincerely for the input that you've given us. And lastly, I want to wish all of you the very best for the rest of the week and the month. If there's any other information that you'd require, you have Amina's details. We urge you to contact her and to engage with her on if you want to be a member as well of Minara. It's a very simple process. Amina will just send you a form and you can benefit from lots of information that we share with the public largely. So if there's nothing else, which I don't see, but if there's anyone that needs to ask further questions away from today's seminar or rather webinar, then what you should do is pose the question over to Amina, who will then direct it to Lorainne, if that's okay with you, Lorainne.
Absolute pleasure. You're welcome to direct any questions or queries regarding that. We're busy currently working with a whole lot of companies to assist them. So I'd be very happy to assist.
Many thanks for that, Lorainne. You've been a star. Well, with that, I want to wish everybody a pleasant day ahead, and God bless. Thank you all. Bye-bye.
Thank you.
Bye, Lorainne.
Bye.